Welcome to the Probate Nation. People are living longer thanks to good health care and healthy lifestyles. Yet as we age, not everyone remains as sharp as they were earlier in their life. Frequently, a loved one, a son or a daughter, is called upon to take on the responsibility of helping an elderly parent with their financial and medical decisions. But even more importantly, the parent has not executed key legal documents to formalize the authorization of that assistance. Over the course of 2 shows, we will learn about the legal process available to acquire that legal authority as a court-appointed guardian and conservator of your parent who lives in Fairfax County. We are fortunate to have as our guests local attorneys with experience in these matters. They will serve as our guides about all that is involved. And along the way, they will point out common problems and pitfalls to avoid that often arise if you elect to board and ride on what we refer to as the living probate train. Our first guest is a founding partner of the Fairfax law firm of Cuccinelli Geiger. Her practice focuses on estate planning, probate, and adult guardianships. She serves as a certified guardian ad litem for incapacitated adults. She is a member of the Fairfax Bar Association and the Northern Virginia Women Attorneys Association. She is also a member and past board member of the Virginia Academy of Elder Law Attorneys and currently serves on the Board of Governors of the Virginia State Bar Trust and Estates Section. Our second guest is a partner in the Fairfax law firm of Yates, Campbell, and Hogue. His practice focuses on estate planning, estate and trust administration, fiduciary controversies, tax matters, and tax return preparation. And he also serves as a certified guardian ad litem for incapacitated adults. He has been a Virginia CLE presenter and a presenter at conferences held by the National Academy of Elder Law Attorneys and the Virginia chapter of NAELA. Please welcome attorneys Kerry Cuccinelli and Mark Christopher. Welcome both of you. Thanks for taking the time and coming in to talk to us. The very first thing I want to talk to, Mark, I want to go to, we talk about some of these important documents that people ought to have as part of their estate planning in preparation for possible incapacity. So what are some of the more important medical decision-making documents that someone can or should execute?
First, an advanced medical directive, including a medical power of attorney. It would include a living will section and releases and authorizations for HIPAA.
And then for purposes of making financial decisions, what's the important document that should be executed to handle that?
A general durable power of attorney. This grants someone the power to administer the property of the person granting it.
Now, Kerry, will the existence of these documents preclude the need to have to go to court to get a guardian or conservator appointed?
Not necessarily. Those documents could be stale, which is to say that the person who was appointed to serve in those documents might not be able to at the time that they're called upon to act. And there's not a backup named. So that those would be 2 reasons why there still might need to be a proceeding before the court.
Okay, so let's go ahead and then start to get into this, what we call the legal proceedings of last resort. So Kerry, if someone has not executed these documents and they no longer have the capacity to do so, who can make these decisions for them?
Well, there is in Virginia a surrogate decision-making statute. So it is possible that certain family members in an order of priority can make certain decisions for individuals if there's not an advanced medical directive. And if on the financial side, if there is a joint owner on a particular account, that person may be able to make decisions for the other account owner, but it's very limited. And typically there is no allowance or statute in Virginia that provides a priority of decision makers that would take the place of a guardian and conservator.
Okay, so Mark, given what Kerry just said, in the absence of those special situations and the execution of these important decision-making documents, are there legal proceedings that can be initiated to help somebody make medical and financial decisions?
Yes, if there's no medical directive, a guardianship proceeding can be initiated. And if there is no power of attorney, a conservatorship proceeding can be initiated.
So the conservator, though, Mark, that's the person then that essentially is given a court-ordered power of attorney in effect? Is that correct?
Yes, the conservator is someone appointed by the court to administer the property of an incapacitated person.
Okay, let's turn now to the process, the formal process to obtain a guardianship or conservatorship. This is a formal process to initiate a request that someone be appointed the guardian or conservator of an incapacitated adult. Let's discuss an important issue that must be considered at the outset, even before the petition is formally filed, and that issue is bonding. Kerry, all guardians appointed must be bonding. Could that pose any problems for someone desiring to be appointed a guardian?
It can be. Not so much with respect to the guardianship piece, but the conservatorship piece. A bond is your promise to uphold your duties as a guardian and conservator. The guardianship bond is typically not secured, which is to say it's a personal promise, and there is no need for surety. On the conservatorship side, that is as I describe it to clients, it's an insurance policy that ensures that the conservator will not misuse the funds that they are controlling. And if they were to do so, there would be coverage for that loss. The person who is seeking to be bonded will have to provide information to the bonding company to ensure their creditworthiness, whether they have any criminal history, any past bankruptcies. So that's the process.
Okay, so the important thing, I guess, to take away from this bonding discussion is that if you're going to petition the court to become a conservator, you are going to have to get a bond with surety, and we want to make sure that you would actually qualify. So that's important to get that checked out in advance. Say, Mark, the formal process to initiate a request for the appointment of a guardian or conservator is through a pleading called a petition. The person making the request to the court is called the petitioner. Briefly tell us what goes into the petition.
Yes, first there would be information about the person's circumstances. Typically, there will be an evaluation report that will be attached to the petition. In addition, there will be information about the whereabouts of the person, their address, and so forth. There will be information about immediate family members, typically at least 3 family members. Information will be provided about that person's marital status, children, parents, siblings, and so forth. If the person is in a hospital or nursing home, notice must be given to that institution as well. The person that we believe is incapacitated is called the respondent. So is a medical evaluation of the respondent by a physician typically filed with the petition? Yes, it is usually attached.
And is that usually filed under seal, or is that a matter of public record?
It is filed under seal.
Great. Kerry, let's go ahead and talk about the guardian ad litem. As part of the process to obtain a guardianship or conservatorship, the court will appoint an attorney to serve as the guardian ad litem. How is the GAL selected in Fairfax?
In Fairfax, the guardian ad litem is appointed by the court from a list of certified guardians ad litem who have passed a course in Virginia to serve in that role.
So those are the you and Mark are both on that list of certified GALs for adults.
Correct.
Now, in order to allow, so what is the purpose of the role of the GAL? What are they supposed to do?
Sure. The proceeding to appoint a guardian conservator is serious insofar as it is taking away from an individual their rights to make decisions for themselves. So consequently, what the court does here is to appoint a guardian ad litem who ensures that the respondent's interests are respected and that service is made on the respondent to ensure that they've been given proper notice of the proceeding, and to notify that respondent of their rights to an attorney, to a trial, and to oppose the petition. I think of the guardian ad litem as the eyes and ears of the judge who can't do that job, and guardians ad litem, the guardian ad litem's role is to provide a report to the court stating the opinion of the guardian ad litem as to whether the petition is appropriate and whether the person requires that support.
So in order to allow the GAO to perform their duties, there is certain information that is needed to be provided. Can you explain what that might be?
Sure. Typically, the guardian ad litem will be provided by the petitioner's attorney contact information for the family, to include the petitioner. So who it is who is asking to be appointed, that person will need to discuss with the guardian ad litem the purpose of the petition, the background, how we got here to this proceeding. Also, information regarding the respondent's medical situation or perhaps mental health situation. Evaluations are provided to the guardian ad litem, and the guardian ad litem has the ability by court order to get information in order to proceed with their investigation.
So Mark, after the petition's filed, the GAO is appointed and does their investigation and files their report. How long before the request will be heard by the court and acted upon?
Typically, there's about a 3 or 4 week time period between when the petition is filed and when we would go to court.
And who needs to appear before the court at that hearing?
The petitioner will be there, the counsel for the petitioner, the guardian ad litem, and typically that would be who it is.
Sometimes it may or may not be the respondent as well?
Correct. Sometimes the respondent will appear and sometimes the respondent will not.
Now, does the proposed standby guardian need to appear as well?
No, a proposed standby guardian does not need to appear.
So how long will the hearing typically last?
Typically only about 5 minutes.
And are these hearings conducted with everybody assembled in a Fairfax courtroom?
Yes, during the situation with COVID, these hearings are done through a WebEx application. So they're held virtually.
So people don't actually go to the courthouse right now, although they may in the future, but presently we do all that over the WebEx, is that correct?
Yes.
Okay. Kerry, so what happens, we've really been talking about, I think, uncontested hearings. So what happens if the petition is contested?
If the petition is contested and that contest or that opposition is noted before the court at that Friday hearing, the judge will likely direct the parties to go to what's called calendar control to schedule a hearing date, which currently may be several months from that point. And that will be when there is a full hearing, a trial is held on the matter of the guardianship and conservatorship. In my experience, oftentimes the attorneys and the parties are aware that a matter is contested prior to getting there on Friday, and some type of settlement is negotiated or a trial date is scheduled.
Yes, normally red flags will have been risen along the way, so we won't just show up for no good reason. Now, Kerry, let's turn to the actual court order. The objective in initiating the request to be appointed a guardian or a conservator is to get a court order approving your request. Is that court order some form of document that the judge simply stamps as approved?
It is a form document insofar as there is language that needs to be in the document to succeed in doing what we're looking to do, which is to confirm that an individual is incapacitated and to provide the authority to the guardian and conservator to do their jobs. However, I would say it's more complicated than that, in that it's one order may not look like another. It's very important to make sure that the order specifically provides for certain powers that might otherwise not be in there.
I think you make a very good point, because this is not a check the box type of an order, because it's not a one size does not fit all. And I make the point about this because we have a lot of folks that may want to try to undertake this pro se, and this is where things tend to fall apart, because the order really requires somebody with some legal knowledge to put everything together in a good document. Now, Kerry, once the court order is signed by the judge, does it confer any authority on the person appointed to act as guardian or conservator? In other words, can they walk across the street to Mom's bank and present that court order and expect the bank to allow them to access Mom's bank account?
Regrettably, no. There's one more step in the process. The guardian and conservator, or one if it's one person, needs to formally qualify before the probate clerk. Pre-COVID, the parties would simply walk down to the probate office and complete that task. Now it's done virtually, but that is still a process. That is still the next step to getting what's called the certificate of qualification. That is the driver's license, in effect, for the guardian and conservator.
So I want to make this point, though. When we have that court order, the court order may give someone the authority to sign a deed to convey Mom's home, but that court order is not going to be really effective until they go to the probate office and do those next steps. Is that right?
That's correct.
Okay. All right, well, now we're, as we look back, we've covered a lot of material over the last, 15 or 20 minutes. As we look back over what we have discussed so far about the Fairfax County process to request appointment of a conservator or a guardian, what are some of the common problems and pitfalls in undertaking this type of request? Mark, I'm going to turn to you first. What are some of the common problems you've come across?
Well, acting unilaterally, the individual, for example, may be undertaking tasks when they don't have any authority. In addition, they need to find a lawyer who's going to be appropriate for the case.
Kerry, how about yourself? What are some of the things that you've seen that were common pitfalls or problems that have been encountered in some of your cases that you've been encountered?
I think for me, a lot of family dysfunction can lead to problems that get presented before the court. To the extent it's possible for siblings to discuss how to address issues with their older or declining parents, all the better, because we have seen a lot of family issues trying to get worked out before the court in these matters.
Okay, and of course we talked about earlier one of the major pitfalls that can occur is not addressing whether somebody qualifies to get a bond if we're going to be appointed conservator. We don't want to go through all this process and show up at the courthouse and then we can't get a bond. We've wasted a lot of time and money. Let's go to some of your closing comments, and we have some extra time here, so let's make sure we make good use of it. There are a lot of moving parts in this process, and this initial program only really scratches the surface as to all that goes into making the process work. Every family situation presents its own sort of set of dynamics and challenges, so hopefully our viewers appreciate that this is complicated and should only be initiated with the assistance of legal counsel. It's not something you should undertake to do on your own. Now, Kerry, Mark, let me ask you some final thoughts and words of advice, practical suggestions you have regarding our discussion tonight about obtaining an appointment as a guardian or conservator of an adult in Fairfax County. I'm going to turn to you first, Mark. Can you give me some of your thoughts?
Yes, I think that it's important to try to avoid surprise. Surprises both among the family members and surprises about the affairs of the respondent in terms of things like knowing what they own, what they owe, what is their income, what are their concerns, and so forth.
And of course, obviously, we always want to try to find the least restrictive way to handle stuff. If that person actually has capacity, we'd like to go back and see if they can sign some of those legal documents we talked about, a power of attorney, advanced medical directive. But if that's not possible, Kerry, what are some of the other advice you might have for folks, at least at this point, based upon what we've discussed so far?
Yeah, I think you're right. It's not necessarily correct that the option of last resort is where one should go without a discussion with, I would recommend, with an elder law attorney. I think having that consultation, talking about the situation in which they find themselves, can help a great deal. Understanding what a guardian and conservator can do and can't do, and making sure that all avenues have been researched to make sure that the guardianship and conservatorship is appropriate, can save a lot of headache and a lot of stress for the family.
Now, I think before we leave this, I want to also, there is the fact of the matter that contested matters, which we only touched on briefly, and this program is really not about, contested matters can be incredibly, incredibly expensive. And I think you guys might want to echo this, that if there is some sort of discord among the family about who's supposed to be in charge or who should apply, they ought to keep that in mind. And if they can't resolve it, have any of you guys used outside mediators to kind of resolve that problem, hopefully among the family, to get somebody identified? Kerry, how about yourself?
Yeah, we have used mediation in contested matters, and in some cases, prior to actually filing, mediation can be an extraordinarily helpful tool for families to come to an agreement without having to go to the costly nature of protracted litigation.
Mark, how about yourself? Have you used mediation to try to get people together as far as how to proceed?
Yes, it's important to know that the mediator is not an arbiter. So the decisions and recommendations of the mediator are brought forth to everyone, and then they can decide whether or not they're going to agree.
I think that is important. A lot of our mediators that we've seen, of course, are retired circuit court judges who have addressed these problems on a regular basis during their 15, 20, or 30 years on the bench. So they're awfully skillful in mediation and telling you how it's going to all work out. Well, guys, I want to thank you both very much, Kerry Cuccinelli from Cuccinelli Geiger and for Mark Christopher from his law firm. This has been a wonderful experience and great information and a great service to the folks of Fairfax County. And I hope I can ask you guys to come back and continue the discussion in part 2 when we get around to taping that. So thank you very much both. You know, if you need to petition the Fairfax County Circuit Court for the legal authority as a guardian and conservator, what our guests shared in part 1 should be incredibly helpful. Clearly, there are numerous steps to take to get your request to court so a judge can rule. And many of those steps deal with legal requirements both in the documents filed and in decisions to be made. But this show is only the beginning of this discussion. In part 2, our guests will complete our education as we head to the probate office, get officially qualified to serve, and then board the living probate train. We encourage you to tune in for part 2. This brings us to the conclusion of our show. We hope it was informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.